And thank you so much to Hope and Naz. We appreciate your sharing your stories to set the stage for the day's conversations. It's important for all of us to be reminded of the human impact of the policies we're discussing today. And many detained individuals, as Hope pointed out, don't have the benefit of strong community support on the outside to help make sure that their needs are being met. Your experiences shed light on the impact of detention on families and on access to counsel, and give us reason to explore the appropriate use of alternatives to detention, the topic of our first panel today. Our esteemed panelists are experts on either alternatives to detention or pretrial services programs, enforcement tools in the immigration and criminal justice systems that are rough analogs, both designed to serve the government's purpose in ensuring compliance with court hearings. Alex Narasta, Immigration Policy Analyst at the Cato Institute, will moderate the discussion. Prior to joining Cato, Alex was the Immigration Policy Analyst at the Competitive Enterprise Institute. He's been published and has appeared in major print and television media across the country and holds degrees from George Mason University and the London School of Economics. Now I'll turn it over to Alex and the panelists who will shortly be on stage to frame the topic and introduce our speakers.
Offender to legal hearings, and that often ends with removal, release, or some other final action. But during that process, a wide range of detention options are open to the government, from release with a bond to detention, detaining the individual alleged offender in an immigration facility, to myriad other alternatives. With roughly 400,000 people removed from the U.S. last year, immigration detention policies affect a large number of people, and those policies must treat offenders humanely in accordance with our laws, traditions, and values. Now, on the economic side of things, it costs the government, on average, $164 a day to detain a single person in immigration detention. Our immigration system holds roughly 34,000 people at any given time, producing an average cost of around $5.5 million a day. Alternatives that have been tried range from 30 cents a day to $14 a day, small fractions of the current costs of immigrant detention. Now, in February, we were granted a rare glimpse at immigration detention policies changing in front of our eyes, however minor, when ICE engaged in its own bit of sequestration theatrics and released over 2,000 detained immigrants from around the country. Now, there was a lot of shock and outrage from some parts of the country over that act, but very few people asked why nonviolent offenders were held in detention in the first place. Today, I think our distinguished panel will shed some light on the current state of immigration detention policies, why they exist as they do, and present some effective alternatives that create a high level of security, treat alleged immigration offenders humanely, and hopefully save the government a huge pile of money in the process. Now, let me give you a rundown of how this panel will work. First, I will introduce our distinguished panelists. They will talk for about 8 to 10 minutes each, and then I will begin the question and answer session with a query directed at all of them. After that, I would like to open up the floor to questions. Speaking first, we have Mr. Timothy Murray. Timothy J. Murray has worked as a criminal justice practitioner at the local, state, and federal levels. His extensive pretrial services experience includes management and executive positions with the Washington, D.C. and Miami-Dade counties pretrial services system. While in Miami, he was the principal architect and administrator of the nation's first drug court. He went on to serve with the U.S. Department of Justice as first director of the Drug Court Program Office. Second, we have Brittany Nystrom over here on my far right, your far left. Brittany is the Director for Advocacy at Lutheran Immigration and Refugee Services in Washington, D.C. LIRS advocates on behalf of refugees, unaccompanied children, immigrants in detention, and other vulnerable populations, and for providing services to migrants through over 60 legal and social service partners across the United States. Brittany has testified before the U.S. House of Representatives and the Inter-American Commission on Human Rights. She also participates in the Board of Immigration Appeals pro bono project as a volunteer case screener. Immediately to my right, Clifford D. T. Keenan, Director, Pretrial Services Agency for the District of Columbia. Before becoming director in 2012, Mr. Keenan served as Deputy Director of the Pretrial Services Agency for the District of Columbia since 2005. In 2000, Mr. Keenan was asked by then Deputy Attorney General Eric Holder to work on expanding community prosecution efforts throughout the country. He became counsel for community prosecution in the Office of the Attorney General, Office of Justice Programs. There he worked with prosecutors and programs across the country and helping to develop their own community prosecution strategies. In September 2001, he returned to serve as chief of the Superior Court Division. The Superior Court Division is responsible for the prosecution of most of the local crimes occurring within DC, from misdemeanors and homicides. To my immediate left, Julie Myers-Wood, President, Compliance, Federal Practice, and Software Solutions at Guidepost Solutions, LLC. She is the former Assistant Secretary for the U.S. Immigration and Customs Enforcement. Julie is the President. She has served in many different capacities in both public and private life. She has helped business compliance for companies and educational institutions large and small. Ms. Woods is the former President of ICS Consulting, LLC, a specialist in compliance monitorships, federal business contracts, and immigration and customs investigations. In her current role, Guidepost Solutions acquired ICS Consulting in September 2012. While with ICS, Ms. Wood was instrumental in developing proprietary software products, including Secure ID, ICS, EVOL, and Easy Cert or Origin that assist employees with compliance issues. So let's begin with Mr. Murray.
Thank you. Good morning, everyone.
Good morning.
I'm local, and as I was getting ready to come in this morning, I was putting on my grown-up suit and tie. I said to my wife, honey, in your wildest dreams, did you ever think that I would be invited to speak on a panel at a session hosted by Human Rights First on pretrial and immigration reform? Without blinking an eye, my bride looked at me and said, sugar, my wildest dreams have nothing to do with either you or reform. So this is working. Good, good. How y'all doing? So why the heck pretrial justice in a group that has come together predominantly because of your interests in immigration reform? And I hope that this panel will help expose the similarities, sometimes painful, sometimes tragic similarities between these two thematic issues. As we meet here this morning, 2 out of every 3 inmates in America's jails, 2 out of 3, are not there as punishment for a crime they've committed. They're not there because they're so dangerous we have to keep them in a cage to be protected from their predatory natures. No, almost 2 out of 3 are there simply because they don't have the money in their pocket to participate in the way pretrial justice operates in America. Ironically, many of them, once they are found guilty, and most of them will be, most of them, in fact, will plead guilty. Once we get to that day, we send them home. So while they're presumed innocent, they're so dangerous and they're so scary, we have to keep them locked up at a cost that the Attorney General estimates at $9 billion a year. But once we give them a chance to raise their hand and say, yep, I did it, you got me, we send them home. Probation, time served, community service, whatever. The only thing keeping them in jail is their financial status. Because like immigration policy, our institutions tend to treat people who get arrested as they're pretty much all the same. People charged with stealing a car are pretty much the same as everybody else charged with stealing a car. Drug possession, bad checks, whatever. Our institutions have, I think, a natural difficulty in moving away from a one-size-fits-all approach to assessing risk or responding to actions such as detention or arrest. People who get arrested in America don't fall into a one-size-fits-all category, do they? Some people who get arrested are really scary. Some people who get arrested are really dangerous. But for the most part, in the US today, we support a system that is fundamentally incapable of separating those who are dangerous, those who are scary, from those who pose such little risk that they can safely be released to rejoin their jobs, their families, their communities, absent the horrific physical and social costs associated with pretrial detention. So how do you fix it? First, you have to get through the notion that the general public has of, well, things must be working pretty well. Why else would our government institutions do it? They must be achieving some relative efficiencies in terms of costs. They must make sense. Why would we do this stuff if it doesn't make sense? Why would we take two individuals as different as Mother Teresa and Jesse James and put them through a criminal justice process and pretend they pose the same level of risk if it doesn't make sense? And tragically, in criminal justice in this country, much like immigration, people assume it makes sense because we've always done it. In the last few years, pretrial justice reform, like immigration reform, has found unprecedented national attention and holds promise that few could even dream were possible. How did pretrial justice get to that position? Data that shows the number of people that are kept for no good reason simply because they don't have dollars to pay a financial bond, inherently discriminates against those who don't have money. That has racial implications, that has social implications. And we know empirically from the data that the paying of that money, which most of them never get back, by the way, does nothing to protect any of you, nor does it do anything to assure their appearance in court. The personal stories of individuals who have been victimized by this nonsensical process, that helps move the needle a little bit as well. Frank Sherry had an op-ed piece in the Washington Post 2 or 3 weeks ago about immigration reform, and Frank Sherry pointed to the personalizing of this issue as one of the elements of having brought immigration reform to the state it is this morning. Public has very little appetite for throwing money down a drain these days, much less so than just a few years ago. The public is much less willing to assume its leaders and its policymakers, its policy enforcers are doing the best possible job they can. But I think in our case, pretrial justice has advanced because of the development of science, of actuarial science, of the ability to not only cast risk prediction, but to have that make sense to the general public and ultimately to lawmakers and law enforcers. I have a 16-year-old daughter. She's learning how to drive. Don't go out on the street. Now, when I go to Nationwide or Geico or any of the big insurance companies and I say, how much to insure my little princess? They say, $43 billion a year. Well, how much to insure me? And they go, 54 cents a year. I go, but we're both drivers. We're both defendants. We're both immigration subjects. Yet we're as different as night and day. The risk posed by my little princess on the streets of America is enormous compared to me. Does that mean she will have an accident? Nah, but in her case, it probably does. Does that mean I won't? Not necessarily. But the data are so compelling that commercial enterprise that lives and dies on monetary profit hedges all of their bets on data. Having learned those lessons and importing those principles into the public policy sector, we have finally, after 50 years, started to make inroads. As I started, however, I end. People assume our institutions know what they're doing and are using the best possible tools in the best possible way. And that perception is, in fact, in my opinion, the most difficult thing to overcome. You can show slam dunk compelling data. You can hold up the personal stories that have faces and feelings. You can show how the cost of a rational, safe, and effective approach is a fraction of the cost of the current policy. You can show outcomes, cold, dispassionate outcomes that point to resounding success when you use risk assessment, when you use appropriate interventions, when you use support. But what you can't do is dissuade practitioners and policymakers that the current approach is broken. You have to approach it not as though it's broken, and not in ways that criticize those that have grown up professionally in these systems, become good at it, and thus got promoted or elected, but rather hold up the advantages in terms of public safety, public cost, and the impact on individual human beings. And you have to keep ringing that bell over and over again. I'm thrilled to have been invited to meet with you this morning. I feel there is a kinship that's undeniable between the work that immigration reformers have been about for several decades and the people of my tribe. I welcome this kinship, and I look forward to spectacular things that will result for each of our communities. Thank you.
That's a very tough act to follow, but I'll give it a shot. I'm going to try to build on some of the ironies and the assumptions and the nonsense that we heard about in the pretrial criminal justice system with a deeper look at what's happening in the immigration detention system. Alex gave us some facts at the beginning, but I'm going to run through some of those again just to make sure that we're all starting from the same place. In fiscal year 11, ICE not only deported 400,000 people, but they detained an all-time record high number of non-citizens. They detained 429,000 people in one fiscal year. That averages out to about 34,000 people in our immigration detention system each day. As we heard, that's about $164 per person per day, and it comes out to around $2 billion a year in American taxpayer costs. This 34,000 per day number is not coincidental. It is, in fact, a level of detention that the US Congress has mandated. They have specifically written into appropriations language that ICE shall detain 34,000 people per day. A note again on some of the ironies with the immigration detention system as a large. This is a civil detention system. So unlike pre-trial, which is in the criminal context, immigration is by definition a civil authority. This might seem like a clash because what we're used to seeing are non-citizens held in usually county jails, in prison jumpsuits, in the same pods that someone in pretrial detention or serving their sentence may be held. One difference with many people facing immigration detention is that they don't know how long they're going to be there. They're not serving a sentence. They may be waiting for an immigration court date, or they may already have an order of deportation that they're just waiting and waiting and waiting for that to be carried out. Some individuals in this mix are required to be detained by law. They are never going to see a judge for a bond hearing. They are never going to be considered for a release because our immigration laws mandate that they be in detention until they are deported from the country, or in some cases granted relief. There are some choices that ICE has to play with when they apprehend someone. If they have that discretion to detain or not, they have that option. As I mentioned, many people are in mandatory detention, and ICE follows through on that and detains them. If they're not in mandatory detention, ICE can release individuals. They have the congressional authority to do that. They can release them in a number of ways: bond, parole, on their own recognizance, on an order of supervision, or they can enroll them into an alternative to detention program. They can also combine these options. They can parole someone with a bond, or they can release them into ISAP 2, which Julie will tell us more about, and require a bond. Earlier this year, ICE did begin nationwide risk assessment program that we hope will lead to more informed decisions, similar to what Geico and Allstate are using to tell us our auto insurance rates. It's unclear, though, how this assessment will bump up against that 34,000 bed mandate. If, say, ICE is currently detaining 33,000 people Monday morning, and they run this risk assessment tool and someone comes up as a low risk, they might opt to detain that person until they get to 34,000. So it's too early to tell how that bed mandate is matching up with the risk assessment tool. Why ATDs in the immigration context? Many of the same rationale as we heard about earlier. The cost savings are enormous. Most of the alternatives programs are pennies. The most intensive forms of supervision are around $22 per day. Remember, the average cost of detention is $164 per day. But maybe a more compelling argument is whether detention is appropriate for someone charged with a civil violation. And many of those in the immigration detention system have enormous vulnerabilities. They may be survivors of torture, they may be fleeing persecution, they may be the sole parent of a US citizen child, they may be elderly. There are a whole range of reasons that someone will do better and fare better if they are allowed to remain with their family and with their community while their case is pending. And again, the immigration detention system is not designed to be punitive. No one is being held by immigration authorities as a form of punishment. The only reason we have an immigration detention system is to ensure that individuals comply with their immigration court proceedings and comply with a removal order if one is issued. So what are some of the other options that are not on the table today? At Lutheran Immigration and Refugee Service, we are looking at a program that would fill some of the gaps in this continuum. Currently, we have the range of options I laid out for releasing individuals, but we don't have any option that matches individuals with a form of case management service, with a system that will support them and help them to meet their responsibilities under our immigration process. It includes partners in 7 different cities: the Tucson, Florence, Phoenix triangle in Arizona, Seattle, Tacoma, Washington, Austin, Texas, the Twin Cities in Minnesota, Chicago, New York City and Elizabeth, New Jersey, and finally Boston. Participants in this community support network are typically referred by immigration attorneys or legal service providers who come across them in detention, think they would do well in a community-sponsored release program, and refer them into the program. this may help someone actually be released on bond. If you imagine an immigration judge is deciding whether or not to release someone, and they can say, I have a slot open in this new community support program. They will match me up with housing and legal services and the support that I need. An immigration judge may be more inclined to grant release if they know that someone is going into a supported situation. This community support network is currently funded by our own funds, as well as monies from the Evangelical Lutheran Church in America and Presbyterian Disaster Assistance. Participation in this program is voluntary. Individuals who do participate are currently in removal proceedings, and they have been released or about eligible for release with needs that can be met by this kind of case management system. We're just starting our second year of the program. So unfortunately, we don't have that data that we know is so critically important to showing ourselves and the American public that this is a workable, cost savings, rational idea. We know that that data is essential, so we're collecting that. We're hoping that we will come through this program with a solid set of data that confirms our assumption that this is more cost effective and that it is more effective in helping individuals integrate, comply, and become independent. But currently that is a hypothesis at this point that we are working to establish. Some of the core services vary on individual participants' needs. So we are doing a kind of individualized assessment on participants in this program. It's a very client-centered approach. It matches individuals with housing needs, legal services, and makes referrals to mental health treatment or educational or employment assistance as need be. So we'll see. The results, as I said, are pending, but we have an option now that we can compare to some of the other ICE release options, as well as to the immigration detention system. So stay tuned. We'll be happy to report how this plays out. It's currently on a 7-year trajectory, and we're starting year 2. So we'll be reporting back out frequently with more data and hoping to humanize some of the stories as well of individuals going through this support network.
Thank you. Good morning. I wasn't exactly sure what I was going to say when I was up here at first, but I think Tim gave me a nice segue. I've got 8 children, and they're all driving. So, Tim, good luck. No, but so you know, to add a little bit to what Alex said about me, my 30 years before coming to the Pretrial Services Agency was in law enforcement. I spent 10 years as a police officer and 20 years as a prosecutor and assistant U.S. attorney here in D.C. And I can tell you, in the 10 years that I was a police officer, I arrested hundreds of persons. And I know, beyond any shadow of a doubt, that I had probable cause to charge each of them. When I was a prosecutor, I prosecuted literally thousands of people. And I know in my heart that proof beyond a reasonable doubt was going to be established. One of the things I didn't take into account at that time, though, was the presumption of innocence. Because as a law enforcement officer, as a prosecutor, many times I'm thinking, this person needs to be punished. And many times it's as easy as asking for a high money bond that the person is not going to be able to meet in order to get that that 1 ounce of flesh, if you will. And that's a wrong attitude. It's a bad culture, that I think often permeates law enforcement, because there is this, tension between the officer, the prosecutor, making sure that the case is there without giving much regard to the presumption of innocence. Having worked now in pretrial services for 9 years, I am very much taken with the fact that we need to do a better job collectively around the nation in informing all of us, not just the communities, but also the legislatures, the police, the prosecutors, public interest groups, that everyone is entitled to that presumption of innocence. Because as Tim said, today, 2 out of 3 persons who are sitting in jail are sitting there because they cannot post the money to meet the bond imposed by the court notwithstanding that person's presumption of innocence. In D.C., we get from the D.C. jail every week a report of persons who are being held in the jail on what they believe to be a cash or a money bond. The jail's population capacity is about 3,000. As of Friday, they had a population of about 2,400. Today, there were 14 persons, 14, who were in the jail because they didn't have a money bond that they had posted. I did a quick review. 7 of those are actually being held on other matters, so they were just looking to get credit for the time that they were, serving in this regard. So in D.C., 7 people out of almost 2,400 are in jail pre-trial because of money. How is it that we're not seeing the 2 out of 3 that Tim alluded to? Because in this jurisdiction, back in 1992, in order to address a rampant violent crime problem that the streets of D.C. were being subjected to, the city council was persuaded by the U.S. attorney, by the defense bar, by the community to change the laws in order to make for a more robust preventive detention statute in order to get persons who were deemed by the court following all of their due process rights in terms of a hearing and everything else. Those persons could be held without bond because they did in fact pose a danger to the community or to a person within the community. At the same time that law was being passed, the former director of pretrial services, a man by the name of Jay Carver, slipped in language into the statute that said, nor shall a money bond be able to be used to hold a person pre-trial. That was a big culture shift for the prosecutors, for the police, for the judges, because beginning in 1992, the reliance on money, which had been basically the norm up to that point in time, started to be chipped away. Law enforcement, prosecutors, they started to realize that money was not appropriate. A person should either be held because they were a danger or a flight risk, or the person ought to be released on certain release conditions which were appropriate for that person, with the presumption being release on personal recognizance. This was a big change. In D.C., fortunately, we had a very robust, even back then, pretrial services agency which could fit the need, fill the requirements that the court would impose in order to assure community safety and the defendant's return to court. Judges came to rely upon pretrial services, so rather than imposing a $1,000 cash bond, the judges were releasing persons to the supervision of the pretrial services agency. We did as we do today, we do a very thorough background investigation on the person. We look at their risk, both for safety purposes as well as for return to court purposes, and we make recommendations to the court. The court then listens to the arguments that both the prosecutor and the defense make about whether or not this person should be held, or if they're to be released, whether it should be on straight personal recognizance, or if they're to be released on certain conditions, again, in order to assure community safety and return to court. It's working. It's working in D.C. We would submit it would be working in most other jurisdictions if persons and organizations and the criminal justice community would be willing to give it, the chance. And that's what we're doing in conjunction with the Pretrial Justice Institute, and other organizations, trying to get other jurisdictions to look at the statute that we have it here in D.C., try to give it a shot. Now, one of the things that I don't know, and I'll be very honest with you, in the immigration standpoint, in the criminal justice standpoint, there is that presumption of innocence. When you're talking about detained illegal immigrants, the only corollary I can make in the criminal justice system is when we have a fugitive case. If a person is arrested in D.C. and they're wanted in the state of Maryland or the state of Virginia or New York, that person is deemed to be a fugitive. Given their fugitivity status, there is a presumption that the person may flee. So in that situation, the law requires under the Interstate Compact that the person can be held without bond for up to 3 days for the other jurisdiction to come and pick that person up. Or if the person is going to fight their extradition and they're requesting a challenge to their extradition, a hearing will be set. And at that point in time, typically the court has no choice but to put some conditions of release, which could also include a money bond. Now, once again, is an illegal immigrant deemed to be a fugitive? Regardless of that, We think that a risk assessment, a validated risk assessment, which identifies whether or not this person, regardless of which system they're in, do they pose a danger of flight, do they pose a danger of risk to community safety or to any other person, is the most viable, is the most fair, is the most humane way of handling people in order to address whatever the issue may be. As I said, here in D.C., 7 people out of 2,400 currently are sitting in jail pre-trial because they don't have the money. But those bonds were just issued last week, and we would like to think that they will be making it, if they haven't already, they will be making it this week. Why isn't the same able to be done? How many persons are we, how much money are we saving by not having persons incarcerated, notwithstanding the presumption of innocence? We think it's a viable system. Again, changing culture, changing attitudes is the way to go. We have to begin somewhere.
Human rights first, and particularly Eleanor Acer, who kind of drew me into this a few years ago, and Ruthie Epstein for all the work they've done really all around the country in thinking about how can we do this differently? What are we doing now? How is it working? And where are there places that it's not working? And, you know, can we really open up kind of some new dialogue here? And I think to go back to the beginning, you got to go to the end. And what's the end goal for ICE? The end goal for ICE is not that it holds a certain number of people in detention, right? The end goal of ICE is that removal orders are enforced. And detention was traditionally seen as a means of getting to the end. And I think the question that we need to ask, particularly as we're coming up on immigration reform, is that the most effective means? Or how can we think more creatively, as Brittany and others have talked about, to look at effective means to get to that end, which is not holding people in facilities, but making sure that removal orders are enforced. But I think when we think about this, you know, how can we be more effective in the means, we have to face a little bit of reality first. And that is that ICE has historically done a terrible job in managing its non-detained docket. One of the studies that was done back in 2003, and I have to refer back to that one because it's been a really long time since we've done it, and metrics and data continue to be a problem in the immigration system. The study done in 2003 by the Inspector General said that if an immigrant was not detained, what chance do you think there was that the immigrant would actually go home if ordered to go home? Anyone have any thoughts? Anyone think it's over 50% chance that the immigrant would go home? What about 60% chance? 30% chance? 20% chance? 13% chance. And so when ICE was managing its non-detained docket, if there was an individual and they were not detained, they were ordered to go home, only 13% of the time would they actually do so. That's a bad statistic, right? It's a really bad statistic. And so, you know, I think for ICE and for the former INS, one of the defaults had been detention. Because if people were detained, you know, they were ordered removed, they would go home. Well, you know, I think it's in the upper 90s, 94, 95% of the time, they would go home. And so I think for ICE, it became very quickly a default. Well, we can be more successful if we simply detain people without thinking about, are there ways in between ICE's effective no management of the non-detained docket and detaining people that might actually work. And what I wanted to talk about for a few minutes this morning is the current program that ICE is doing, which I think does work and has some good metrics and some good results.
And we may be forced to see what other creative options we can come up with for a purely budgetary reason. But if immigration reform is passed and you take many of those customers out of the detention pipeline, the private prison industry may lose some of their sway. But I do think it's good to keep in mind that there is that voice out there in the debate. They may also be channeled into creative options for more civil detention facilities. Julie referenced this counterintuitive word of civil detention. In Texas last year, a new type of facility was open to much hoopla from ICE. And honestly, it is a better detention facility. It has more freedom of movement within. It has more services for the immigrant detainees who are held there. But it is still detention. It's still surrounded by a barbed wire fence, and you're not allowed to come and go. But it involves the private prison industry in a way that conditions are significantly better than a county jail, which is right now the de facto. So I'm not saying the private prison industries are always bad or that they're always good. It's a very controversial issue, but maybe if we are stuck with immigration detention facilities, as your question suggested, maybe we can be looking to industry to do it better.
Yeah, I think when you think about this facility in Texas, it's a GEO facility. GEO owns the facility, GEO runs the facility. It's a good facility for, that if you're going to detain people for that kind of detention. I think a lot of outsiders who've looked at it. Now, the question is, could ICE as a government build that kind of facility, do that kind of facility on their own? The answer is no, they could not. And so when ICE looked to civil detention model, and I know there'll be more talk about that today, they looked to either private or potentially state and locals to do that sort of civil detention, and they needed the nimbleness of industry or state and locals. I think one big stakeholder that you did not mention who really has a loud voice are also the state and local sheriffs. I know that when I closed several facilities in a certain part of the country, I heard from the senators, I heard from the representatives about why we were closing the facility. And so the sheriffs have very loud voices. And so I think you have to look at also they're called IGSAs, those state and local owned facilities, and what are the conditions in there? And the end game should not be, in my view, who owns the facility. The end game should be, do these people need to be detained? And then what are the conditions? Are we treating these people with dignity and respect, and are we abiding by that? And how can we best get to that, whether it's publicly owned, privately owned, or state and local owned?
Our work has a natural enemy in the form of the bail bonding for profit industry. They don't want informed decision making. They don't want risk assessment. They want every one of you who gets arrested to have to pay them. If you were them, you'd want the same thing. This is nothing against them as people. This is everything against a system that supports their profit taking. And I would suggest that the immigration reform movement has a lot to learn from the bitter lessons we've learned in the pretrial justice efforts at reform. Just because they have money doesn't mean they win, but when they got money, it's a son of a gun going up against them.
Mr. Alden over here in the corner.
Thank you. Ted Alden from the Council on Foreign Relations. I want to ask you a question. If we begin in the immigration area to move more towards this civil model, how robust is it going to be politically? Because we can all imagine a situation, someone who's released under an alternative program, goes out, they commit a murder, they're a drunk driver, they kill 4 kids, heaven forbid they're involved in a terrorist attack. And then the Secretary of Homeland Security has to go up there and try to defend this system, say, well, look, the metrics are really good. They're much better than the detaining everybody system. This is a much more rational system. Very tough case to make. I'd be interested in hearing actually first from Clifford and Timothy in the criminal context, because I'm sure you run into this. Somebody who your risk assessment says, this is a person we should release, and they go out and they do something horrible. And you've got to defend that system. How do you do that? Because these systems are not perfect. They will make mistakes. And how do you defend them when that happens?
We have an expression that stuff happens. The reason why judges have for years released people who were going to be released to pretrial is so that they could, if a mistake or if something happened that was not avoided, they could say, hey, we did our job. We released them to pretrial. Once again, one of the things that we try to do is manage expectations. Our risk assessment, as good as it is no guarantee that some knucklehead is not going to go out and do something stupid. But that could be a person charged today with shoplifting who has no prior record of violence whatsoever. You would have the same outcry because there is a perception this person was charged with an offense. Why was he released? And again, on our side, it's because the presumption of innocence and the presumption of release on personal recognizance or with the least restrictive conditions has got to apply. But I think everybody has to understand and has to abide by the reality that no system is perfect. And if something happens, so long as you can defend the system that you're using, and once again, I think that our risk assessment is pretty valid, but we've had mistakes happen.
Terrific question, and a real-life question that those of us who've dealt with real-life crooks and real-life judges and real-life newspapers have had to deal with, because there are real-life victims associated with it as well, right? And in my work, which is different than those of you involved in immigration, but with an astonishing number of parallels, I get to point to the existing system, which is ridiculous in its own functionality and design. So when you say, gee, you had a risk assessment that's proven valid 90-some% of the time, but this one guy got out and caused all this mayhem, what about your risk assessment now? You have but to simply point to the traditional mechanism in your country of determining who gets out and who doesn't. And that traditional system hopes to hell you don't have any money when they say 100,000. And oddly enough, when you as the judge says 100,000, the public goes, justice was served, unless the individual has the money. Where did they get the money? Did they go out and commit additional crime to pay for it? Does the system that supports your release on 100,000 benefit anyone financially? If you go out and commit another crime after you pay, and now you have 500,000, is there somebody in the room that's going to profit from that financially? In the United States, there is. And that's a system that the public finds relatively shocking. There's a case, infamous case in the Northwest in Washington State, career criminal, unemployed, gets arrested for something nasty, the court sets $50,000 bond. Those of us who've worked in criminal courts, I'm telling you, for a guy like that, you have buried him under the jail on a $50,000 bond. He makes the bond. He goes out and he does something even nastier. The court goes, oh my, better make that a $100,000 bond. By the time he walked into a diner and shot and murdered 4 sheriff's deputies having breakfast, he was out on over $400,000 bond. I would rather have a system that uses risk prediction and empowers the courts and the prosecution with the defense in the room to move to hold individuals that are unmanageably dangerous and use risk assessment to inform decision-making for the others, than to go to a system where dollars somehow create the illusion that we are all safe, that this stuff is effective, and that it makes sense.
And I would just add, I've been on the receiving end of a lot of the calls where people have, and the non-detained docket, when I was at ICE, the non-detained docket was about 1.7 million, and ICE had at that time about 32,000 beds, and so very large non-detained docket. And so at any given time, there was a very high chance that someone would do something you wouldn't want them to do. Some just mildly bad things, the shoplifting, some very bad things. And the risk, of course, is, you let out somebody, they're a terrorist or something like that. And so I think that's what makes it tough. Even in the face of good metrics, and I think you have to then come by and stand by your metrics and stand by your risk, because that's what makes it incredibly tough. And I think it's very, very hard for the field office directors and the ones who make the release, non-release decisions in the field. When I was a prosecutor, I used to hear that nobody ever got reversed for letting evidence in, when you're, and it's the same kind of thing. If we keep the person in detention, they're not going to be out, they're not going to cause harm. I think that's, and so even sometimes now I think we have a pretty good risk assessment. It's not perfect, but pretty good. And sometimes there'll be an inclination to err on the side of keeping people in detention because they think it's less risky. And so I think it is scary. You bring up the point of terrorism. I do think that's scary when we've seen how people do subvert the immigration system. And, how does ICE make sure that they keep that in mind and that they're doing it in an effective way, and especially kind of in the field, because those bad decisions obviously can cause, big consequences.
I would point out also, though, that the immigration enforcement system is not a counterterrorism system, nor is the crime prevention system. As Julie mentioned, it is designed to ensure compliance with our immigration civil laws. So where this becomes a very charged political public debate it's important to keep in mind that there are separate systems, huge systems designed to prevent crime, respond to crime, prevent terrorism, respond to terrorism, and then you have our immigration enforcement system.
But a lot of times, the FBI is looking to ICE to hold someone in immigration detention because they're building the criminal case. And so I think as the reality is that the immigration system, sometimes, and those are cases that are worked at headquarters and looked very closely, those are not your average kind of run-of-the-mill field cases, but where the immigration system is used, and I think rightly so, to help look at how can we protect our country.
And I think we have time for one very quick question with quick answers. Yes, in the back. Good luck.
Hi, I'm Catalina Nieto. I'm actually undocumented, and I have to say it's a little bit hard sometimes to sit here and listen to people talk about how to arrest us more nicely or how to deal with us, right? How to criminalize us, but in a nicer way. And I just wanted to ask, the way I see ICE and this system, it's actually very oppressive and there's very little dignity. And you start thinking about, the system as a whole as that, it's really a system that's criminalizing and taking our humanity away. And how can we make a system like that that's unjust at its core a little nicer, or should we start shifting the conversation?
Well, I think that's why the conversation has to be at immigration reform. And I think that, there was such a lack or inconsistent enforcement over so many decades and things that we're at this place where I think, most Americans would agree the system is terribly broken. And so how can we have immigration reform to kind of really allow individuals to adjust and then kind of to start anew? But I think one of the questions is then, the day after immigration reform passes and then someone comes into the country illegally, how does ICE kind of deal with it then? And so that's where I think kind of looking and thinking about all these other things makes a lot of sense.
I would agree. I think the system we have now is not working for anyone, and it needs to be overhauled, not just fixed around the edges to make it slightly better, slightly more humane. We do need a truly new, radically different immigration system.
And if I could say, in D.C. and several other jurisdictions, we have moved away from commercial money bonds as a means of securing both community safety and return to court. It's working here. We're trying to get other jurisdictions in the criminal justice systems to be doing likewise.
You need a culture that treats you as an individual and not as part of a class. Just as we work in the criminal justice domain to have those who are arrested, those who are victimized, to be viewed as individuals, each with different strengths, risks, and needs. And that is behind this conversation and other conversations that are going on around the country on this issue. It turns out to be enormously difficult, but it turns out to be essential.
Thank you very much to our panelists, and thank you for Human Rights First for putting this on.